Okay, Mr. Glazier, I have Emiliano Flores is here. Do you need to speak to him?
Uh, is he on Zoom or is he there in person?
He's on Zoom.
Yeah, I could talk to him just briefly, Your Honor.
Okay. All right, Mr. Flores, I am going to put you in a breakout session with Mr. Glazier if you give me just a moment.
Thank you.
Okay, Mr. Sala, I have Mr. Bishop here. Are you going to need a breakout session with him?
No, Your Honor, thank you. We're prepared to proceed. Mr. McCready's on that one as well.
All right, this is file 23-21238-FC, People versus Nicholas Joseph Bishop. We are here today for a pretrial conference in this case, and we are proceeding today by video conference. First, can I have the attorneys place their appearance on the record, beginning with Mr. McCready.
Good morning, Your Honor. Dave McCready for the people.
Good morning, Your Honor. Stan Sala on behalf of Nicholas Bishop.
All right, and where do we stand with Mr. Bishop's case today?
We have worked out a plea agreement. It should be submitted to the court at this point. I have that, and I'm ready to put a plea in the record.
All right, is that accurate, Mr. McCready? I do have a copy of a plea agreement that appears to be signed by Mr. Bishop and Mr. Sala yesterday, and Mr. McCready on March 6th.
That is correct. We've also submitted an amended information.
Do have that as well. Mr. McCready, do you want to place the terms of the agreement on record? I'll ask Mr. Sala to confirm.
Sure, that'll be fine. So we're adding account 2, which is delivery of fentanyl. And we have reached a sentence agreement, which would be a term of probation with no upfront jail. That Mr. Bishop would be subject during and as a condition of probation to random drug and alcohol testing, that he would have to report to probation weekly or as ordered by the court, that he have to find and meet with a recovery coach or a sponsor. Again, that would be weekly or as ordered. That he would attend recovery support meetings in a frequency recommended by probation. That he would be subject to random home checks any time of the day or night at a frequency determined by probation, and that he would follow all other treatment recommendations, seek and maintain employment, and complete 4 community service projects per year. As the people's part of the agreement, then we would dismiss count 1, which is delivery causing death. We've also agreed that there'll be restitution in the amount of $3,604.50. And then we're also agreeing that commensurate with the plea reduction from a delivery causing death to delivery, that we would not be scoring OB3, which is injury to a victim. I think that's the extent of the deal.
Okay, Mr. Saul, is that a complete and accurate statement of the plea agreement?
It is, Your Honor. Thank you.
All right, Mr. Bishop, would you raise your right hand, please? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty for perjury?
Yes, Your Honor.
You are Nicholas Joseph Bishop.
Yes.
Mr. Bishop, you've heard the statement of your attorney and the prosecuting attorney. Is it your intention to plead guilty today to count 2 on the amended information, delivery of fentanyl, less than 50 grams?
Yes, Your Honor.
Do you understand that the maximum possible penalty for that offense is up to 20 years in prison and or a $25,000 fine?
Yes, Your Honor.
Are you satisfied with Mr. Sala and the advice that he's given you?
Yes.
Neither the prosecutor, defendant, or anyone acting on the defendant's behalf has discussed a possible sentence with court other than as it's been placed on the record here today. Is that correct, Mr. McCready?
Yes, it is.
Mr. Sala?
Yes, Your Honor.
Is that also your understanding, Mr. Bishop?
Yes, Your Honor.
If a guilty plea is accepted, there'll be no trial. That means you're giving up the rights that you would have had at trial. I'm going to explain those to you now to make sure that you understand them. You do have the right to a speedy public trial by jury. You could ask for a non-jury trial, and if the prosecutor and the court agree, you could have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty, and you do not have to prove anything. You have the right to be present at your trial, to have the witnesses against you appear at your trial, and to ask those witnesses questions. You have the right to have the court order any witnesses you have for your defense to appear at your trial. You have the right to remain silent during your trial and not have that silence used against you. However, you also have the right to testify at your trial if you wanted to testify. Do you understand, Mr. Bishop, that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at a trial?
Yes, Your Honor.
You also understand that any appeal from the conviction and sentence pursuant to your plea would be by application for leave to appeal and not by right.
Yes, Your Honor.
If you are not a citizen of the United States of America, conviction of a crime can result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Do you have any questions about any of the rights that I've explained to you?
No, sir.
Do you understand that you're giving those rights up?
Yes.
How do you wish to plead to the charge that on or about August 13, 2020, in the city of Adrian, county of Lenawee, that you did commit the offense of delivery of fentanyl less than 50 grams?
Guilty, Your Honor.
Has anyone made any threats or promises to you to induce you to plead guilty to that charge?
No.
Do you understand that if I accept your plea, you'll be giving up any and all claims that your plea is given as a result of threats or promises that were not disclosed to the court on the record this morning, or that it was not your own choice to enter the plea?
Yes, Your Honor.
Is the prosecutor or defense counsel aware of any promises, threats, or inducements other than the plea bargain to induce Mr. Bishop to plead guilty today?
Not aware of any, Your Honor.
None, Your Honor.
Mr. Bishop, has your attorney promised you any particular sentence or estimated what your sentence would be other than as we've discussed it on the record here today?
No, sir.
Is it your own choice to plead guilty?
Yes, it is.
Mr. Sala, do you want to cover the factual basis?
Yes, if I may, Your Honor.
Go right ahead.
Thank you. Mr. Bishop, on or about August 13th of 2020, you were in the city of Adrian, county of Lenawee, state of Michigan, with another individual on that day.
Yes.
And that other individual and you drove to a third party's home to purchase what you believe to be heroin at the time, correct?
Correct.
You were the driver of the car.
Correct.
Okay, so he rode with you in the car. You stopped and picked him up on the side of the road in Adrian and drove him to the location where you believed heroin was to be sold, correct?
Yes.
And he was aware that heroin was going to be sold at that location as well?
Yes.
He was your passenger and you drove to that location together.
Yes, that's correct.
Then you entered the home, you purchased heroin from that third person,
Correct.
and he purchased heroin, your passenger purchased that heroin from a third person. Is
Yes.
that correct? Okay.
That's correct.
And the basis of this plea, based on the prosecutor's position, is that because you drove there, you aided and abetted the actual person who sold the heroin to the passenger who was a friend of yours in the car, correct?
Yes.
Okay. You understand that aiding and abetting is potentially the same penalty as the actual delivery.
Yes.
And the basis of this plea, the factual basis, is that you aided and abetted that individual or friend of yours that you gave a ride to, who purchased the heroin later determined to be fentanyl or possibly have fentanyl in it, correct?
Yes.
And the heroin you purchased from that same dealer had fentanyl in it.
Yes.
Okay. I have no further questions here.
Your Honor, if I may,
Go ahead.
the friend that we've been speaking of was your lawyer, isn't that correct?
Yes. Yes, sir.
All right, thank you. I'm satisfied.
All right. Has the court complied with MCR 6.302 B, C, and D, Mr. McCready?
Yes.
Mr. Sala?
Yes, Your Honor.
All right, I will accept the plea then. It's been given understandably, voluntarily, and accurately. Mr. Bishop has had full knowledge of his rights and he has had competent counsel. Court has not made any agreement regarding the possibility of a plea or sentence in this case with prosecutor, defense attorney, defendant, or anyone acting in the interest of any of them, other than as it's been stated on the record here today. I will refer this matter to the probation department for pre-sentence investigation and set sentencing.
Your Honor, if I could on sentencing.
Go ahead.
Mr. Sala and I are both available on April 7th. I know that's a short turnaround, but Aaron's mom was going to be here. She's from New Jersey. She's coming to Michigan for hearings many times. She's going to be here for the 7th. If there's any way at all that we could schedule sentencing for that date.
That's not a decision I'm able to make. I'm required to give MDOC 6 weeks to prepare the pre-sentence investigation report. And it's just not something that's within my ability.
If MDOC would agree to a quicker turnaround, would that be something that I could work on?
And I'm sorry, what date were you talking about?
April 7th.
April 7th is a Monday. If you would like to contact Ms. Clark and see if we have time available, that's Monday morning is my civil motion docket, and those are usually fairly filled up. So I don't know that I'd even have the ability to schedule it that date. And if MDOC is able to turn that around by April 7th, I mean, I would be willing to do it, but it obviously requires some things that I'm not necessarily in control of.
Understand. I can work on it on my end.
All right. Otherwise, I'm going to set that for April 24th at 8:15 with the understanding that if we're able to work things out, it may be on April 7th.
Thank you.
Your Honor, there are some other issues that regarding what Mr. Bishop has done in regards to helping law enforcement in this matter that the court should consider as well. I think we'll put that in a pre-sentence investigation as opposed to putting that on the record today. It should be helpful for my client as well. And Mr. McCready is aware of that. That's why this was adjourned for a while. And I don't know if the court's aware of that, but it will be in the pre-sentence investigation.
All right. Mr. Bishop, someone from the probation department is going to be in touch with you to do a pre-sentence investigation interview. When you do that interview, please be truthful about this offense, about your background. I will continue bond is currently set, and Mr. Bishop is going to put you, Mr. Sala, and Mr. Jones from the probation department in a breakout session so that Mr. Jones can collect your contact.
Okay,
Thank
thank
you.
you, Your Honor.
Okay, I'm sorry, Ms. Mull, Mr. Colwell is incarcerated somewhere?
Yes, Your Honor. He is at Lucas County Jail in Ohio, related to the instant charge here. And I spoke with their officers. They have specific video court officers available to coordinate with our court to allow him to zoom in. I can provide that phone number for the court.
So I don't understand. We're supposed to call him today?
I'm sorry, Your Honor. We're asking for a brief adjournment, maybe 3 weeks out, and then
Okay.
ask the court to coordinate with them to zoom him in.
Okay, is there anything we need to do on the record today?
Just have the adjournment, and I'll provide the phone number if the court's ready for the video to coordinate.
Can you just put that in the chat to me? I'd rather not. We're on
Sure.
broadcasting it on YouTube. I'd rather not put that phone number out there.
Okay, very good. Will do.
So let me call that one real quick. This is file 25-22125-FH, People versus Christopher Joseph Colwell. We are here today for a pretrial conference. We are proceeding today by video conference. First, can have the attorneys place their appearance on the record, beginning with Ms. McClure.
B.B. McClure, map the people.
Jolianne Mull with Christopher Colwell, who's in Lucas County Jail.
And Mr. Dagger Margosian, you're on this case also, right?
Your Honor, I am. I'm just supervising Mr. Michael Margosian for Mr. Colwell.
Okay. All right. So, Ms. Mull, you had explained to me off record that Mr. Colwell is incarcerated in Lucas County, and we need an adjournment to arrange his presence at the hearing. Is that correct?
Yes, Your Honor. Thank you.
And Ms. McClure, anything we need to address on the people's side today?
No, nothing on map the people.
All right, let's adjourn this then to April 9th at 8:15 a.m. Ms. Mull, would you be able to prepare a stipulation in order for that adjournment?
I can, Your Honor.
And then again, if you want to just put that phone number in the chat, I will write it down and stick it on the file. If you want to call Ms. Clark and give that to her, you can do that as well.
Certainly, I can do that. Is Miss
Okay.
Clark, what's Miss Clark's first name? And I'm learning your staff.
Sorry, it's Francis.
Francis, got it. Will do. Okay,
I think we're
Very
all
good.
set on this. Thank you.
very good. Thank you.
Okay, Mr. Glazier, are you ready to go on the record with Mr. Flores?
Yes, I am, Your Honor.
This is file 24-22069-FH People versus Emiliano Julian Flores. We are here today for a pretrial conference in this case, and we are proceeding today by video conference. First, I have the attorneys place their appearances on the record, beginning with Mr. Bayoneto.
Alex Bayoneto for the people.
John Glazier for Mr. Flores, Your Honor.
All right, and Mr. Glazier, where do we stand with Mr. Flores's case?
Yeah, he's gonna plead to, I think it's count 1, operating while intoxicated, third offense, with the understanding that I think it's mistaken as it's count 3. It's probably supposed to be count 2, failure to report an accident and habitual offender at the time of sentencing. He has been evidently approved for sobriety court, and the agreement would be that as long as he enters in complete sobriety court, there'd be no upfront jail.
Okay, Mr. Bayoneto, is that a complete and accurate statement of the plea agreement?
It is, Your Honor. The only thing I would add, there may be restitution involved in the case. There was an accident. It's unknown what that amount would be at this time. So if there is any restitution, that would be determined at sentencing, but otherwise, everything else was correct.
All right, Mr. Glazier, are you in agreement with that?
I am, Your Honor. I don't know it was a 1-car accident. I don't know if there's restitution. I believe it was his car, but he may have hit something
Okay.
on the side of the road or something.
All right, Mr. Flores, would you raise your right hand, please? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty for perjury?
Yes.
All right, and you are Emiliano Julian Flores, is that right?
Yes.
Mr. Flores, have you heard the statement of your attorney and the prosecuting attorney? Is it your intention to plead guilty today, count 1, operating while intoxicated?
It is. I would like to try to see if I'd be eligible to get my third and habitual dropped down to a second upon completion of sobriety court.
Okay, so my understanding of the plea agreement is that habitual is being, well, this is third offense. Mr.
The habitual I'm talking about is
Yeah.
not, is he has a prior, they say he has a prior felony.
So it's operating, it's third offense operating while intoxicated. It also has a second habitual offender notice. The second habitual offender notice is being dismissed. But Mr. Flores, you would be pleading today to operating while intoxicated, third offense. Do you understand that? Did you hear me, Mr. Flores?
Yeah, I just didn't know if you're asking me or Mr. Glacier.
No, I'm asking you, Mr. Flores. Do you understand that you're pleading today to operating while intoxicated, third offense?
Yes, and I was just wondering if I'd be eligible to have that drop down to a second after completion of sobriety court.
Your Honor, that was discussed between myself and Mr. Glazier. It was not made part of the plea agreement. I would not add that to the plea agreement at this time. So it would remain a third offense regardless of the completion of sobriety court.
Okay. Do you understand that that is not an option that the prosecutor is offering, Mr. Flores?
Yes.
Do you still want to proceed with your plea?
Yes.
Do you understand that the maximum possible punishment for this offense is a fine of $500 to $5,000 and either 1 to 5 years or probation with 30 days to 1 year in jail and at least 48 hours to be served consecutively, and 60 to 180 days of community service.
Yes.
Are you satisfied with Mr. Glazier and the advice that he's given you?
Yes.
Neither the prosecutor, defendant, or anyone acting on the defendant's behalf has discussed a possible sentence with court other than as we've discussed it on the record here today. Is that correct, Mr. Bayanetto?
That's correct, Your Honor.
Mr.
That's
Glazier?
correct, Your Honor.
Is that also your understanding, Mr. Flores?
Yes.
If a guilty plea is accepted, there'll be no trial. That means you're giving up the rights that you would have had at trial. I'm going to explain those rights to you now to make sure that you understand them. You do have the right to a speedy public trial by jury. You could ask for a non-jury trial, and if the prosecutor and the court agreed, you could have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty, and you do not have to prove anything. You have the right to be present at your trial, to have the witnesses against you appear at your trial, and to ask those witnesses questions. You have the right to have the court order any witnesses that you have for your defense to appear at your trial. You have the right to remain silent during your trial and not have that silence used against you. However, you also have the right to testify at your trial if you wanted to testify. You understand, Mr. Flores, that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at a trial.
Yes.
You also understand that any appeal from the conviction and sentence pursuant to your plea would be by application for leave to appeal and not by right.
Yes.
If you are not a citizen of the United States of America, conviction of a crime can result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Do you have any questions about any of the rights that I've explained to you?
No.
Do you understand that you're giving those rights up?
Yes.
How do you wish to plead to the charge that on or about November 2nd, 2024 in the city of Adrian, county of Lenawee, that you did commit the offense of operating while intoxicated, third offense?
Yes. Guilty.
Has anyone made any threats or promises to you to induce you to plead guilty to that charge?
Just that there would be no jail time. It would be sobriety court.
Other than the plea agreement that you've entered, has anyone made any other promises to you or threats?
No.
Is prosecutor defense counsel aware of any promises, threats, or inducements other than the plea bargain to induce Mr. Flores to plead guilty today?
No, Your Honor.
No, Your Honor.
Mr. Flores, has your attorney promised you any particular sentence or estimated what your sentence would be?
Just that there would be no jail time and that I can do sobriety court.
Okay, anything other than what's been placed on the record here today as part of the plea bargain?
No, Your Honor.
Is it your own choice to plead guilty today?
Yes.
Mr. Glazier, do you want to cover the factual basis?
Yeah, Mr. Flores, on or about November 2nd of 2024, you were driving a motor vehicle here in Lenawee County, the state of Michigan. Is that correct?
Yes.
And you were involved in a one-car accident, I believe. Is that correct?
Yes.
Prior to driving, or while you were driving, you were under the influence of alcohol. You had been drinking some alcohol. Is that correct?
Yes, it is.
And I think, I can't remember the exact blood level, but it was certainly over a 0.10, wasn't it? It was higher.
Yes, it was.
All right. And you have 2 prior convictions, one for impaired driving on 3/27/2015 in the district court here in Lenawee County. Is that correct?
Yes.
And you also have a conviction on September 9th of 2022 in the 4th Circuit Court, which I think is Jackson County, isn't it?
Yes.
All right. I don't have any other questions, Your Honor.
Mr. Bayonet, are people satisfied?
Yes, Your Honor.
Has the court complied with MCR 6.302 B, C, and D, Mr. Banetta?
It has, Your Honor.
Mr. Glazer?
Yes, Your Honor.
All right, I'll accept the plea then. It's been given understandably, voluntarily, and accurately. Mr. Flores has had full knowledge of his rights and he's had competent counsel. The court has not made any agreement regarding the possibility of a plea or sentence in this case with the prosecutor, defense attorney, defendant, or anyone acting in interest of any of them, other than as we've discussed on the record here today. I will refer this matter to the probation department for pre-sentence investigation and set sentencing for April 24th at 8:15 a.m. Mr. Flores, someone from the probation department will be in touch with you to do a pre-sentence investigation interview. When you do that interview, please be truthful about this offense and about your background.
Thank you, Your Honor.
I'm going to put you in a breakout room with Mr. Jones from the probation department so he can collect your contact information and give you some instructions on what to do next.
All right. Thank you, Your Honor.
Thank you. Mr. Glazer, he also had a contempt from district court that still needs to be dealt with. We'll just adjourn that to the date of sentencing as well.
Okay, thank you, Your Honor.
Okay, Ms. Dumont, are you ready to proceed with Ms. Steele?
Yes, Your Honor.
Ms. Steele, do you want to come forward to the podium, please? This is file 25-22124-FH, People versus Tricia Lynn Steele. We are here today for, I'm sorry, it is also file 25-22123-FH. We're here today for pretrial conferences in both of those cases, and we are proceeding today by video conference. First, can I have the attorneys place their appearance on the record, beginning with Ms. Arnold.
Allison Arnold for the people.
Katarina Dumont for Ms. Steele.
And Ms. Dumont, where do we stand with Ms. Steele's case today?
Your Honor, I just filed a substitution of counsel on this case. I did get to meet with Ms. Steele. She filled me in a little bit. But at this point, we would be asking for an adjournment if we could get 30 to 60 days so I can work through the discovery and get a formal plea offer from the prosecution.
Okay, Ms. Arnold, anything we need to address from the people's side?
No, thank you, Your Honor.
All right, so.
And Judge, she's doing 2 times a week drug screening, and she's doing very well as of late. Her last 4 have been clean.
Okay, thank you, Mr. Coast. Let's go with May 7th at 8:15 then for an adjourned pretrial date. And Ms. Dumont, would you prepare stipulation and orders for those files?
Yes, Your Honor.
Is there anything else that we need to address today?
No,
No,
Your
thank
Honor.
you, Your Honor.
Okay, so Ms. Steele, then again, your next date is May 7th at 8:15 a.m. You're all set, thank you. Mr. Awesome. No, there you are. Mr. Watt, are you ready to proceed with Mr. Higgins?
Yes, Your Honor.
Is file 24-21964-FC, People of the State of Michigan versus Matthew Virgil Higgins Jr. We are here today for a pretrial conference in this case, and we are proceeding today by video conference. First, can I have the attorneys place their appearance on the record, beginning with Ms. Arnold?
Ellison Arnold for the people.
Your Honor, Elias Muwad appearing on behalf of Mr. Higgins.
And Mr. Muwad, where do we stand with Mr. Higgins' case today?
Allison, do you want to go ahead and tell him? I know we texted this morning. What's going on?
Right. Judge, Mr. Muwad sent me some materials from the case, and it took me approximately 6 hours to download. So I'm going through those materials. I'm actually almost done. I was hoping I'd be ready to do something meaningful today. We do have a final pretrial and a trial date set in June, but can we get another pretrial in maybe 3 weeks just to keep track of it? And at that point, I'll make a final plea offer. I think Mr. Muwad and I are going to have to get together if we go to trial and see there may be evidentiary issues to see if we agree on what's admissible and what's not, that sort of thing. So just to keep track of the case.
Judge, I see this case hopefully playing out. And so if we could get the 2 to 3 weeks, that'd be great. Sorry. That's okay.
Okay. Little booked up. Let's go with April 16th. That'd be 4 weeks. If that's all right, at 8:15.
That's more than fair. And Mr. Higgins, I will be in touch with him and his family.
Okay, then, and Ms. Arnold, then would you be willing to do a stipulation in order to for that adjournment?
We will.
All right. Is there anything else we need to address today?
No, thank you, everybody.
No.
Thank you.
Okay, Mr. Higgins, you can let the officer with you know that you're done with court for today.
All right, thank you.
Mr. Murphy, are you going to need a breakout session with Mr. Dill?
I'm sorry, Your Honor, I didn't hear you.
Do you need a breakout session with Mr. Dill?
Mr. Dill, I don't think that's.
Oh, I'm sorry. Mr. Madison.
Oh, yes, Your Honor, I will need to talk to Mr. Madison. Thank you.
Okay. And okay, Mr. Madison, I'm going to put you in a breakout session with your attorney, Mr. Murphy. I'm going to need you to turn your camera on and unmute your device, please. Okay, Ms. Flores, do you want to come forward, please? This file 24-21886-FH and 25-22118-FH, People versus Emily Christian Flores. We are here today for a pretrial conference in this case. First, can I have Mr. Bayoneto place your appearance on the record?
Alex Bayoneto for the people.
And Miss, you are Emily Christian Flores, is that correct?
Yes, sure.
All right, Ms. Flores, there was a hearing Monday. Mr. Daly withdrew from representation in your case due to conflict of interest with him serving as a county commissioner. I am not aware yet that a he was appointed through the public defender's office as a special public defender. I am not aware of anyone being appointed yet in his place. And so what I'm going to do is adjourn your pretrials to April 16th at 8:15 a.m. And I'm sure that's in process. It's just so recent that nothing's happened. So we'll adjourn it to April 16th at 8:15 a.m.
Okay, Your Honor, can I address an issue though? There's PPO no contact orders that we've been trying to get dropped now. And I have a 9-month pregnant daughter that needs me, that the PPO should have never even been against her in this. And they went to the prosecutor as well to have this dropped. I went and I saw John Bailey, is it, I believe, and paid for the whatever. And I haven't had an attorney to be able to pursue it. I know CPS has been trying to get hold of the prosecutor with no answer. And this is a kind of an emergency.
Okay, so if there's a personal protection order in place, that's a different file.
No contact, it's a no contact, sir, as part of the bail.
Your Honor, she's asking to have the no contact order lifted for her minor daughter, who is listed as the victim in count 4 in 2522118 FH. So I'm not, I wouldn't necessarily agree to it, but I would leave it in the court's discretion. She is accurate when she said that both victims listed in counts 4 and 5 in that file requested dismissal.
I'm sorry, which file was that?
That is 2522118 FH.
And you referenced Child Protective Services. Is there an ongoing abuse and neglect case?
No, there is an open case. I'm working with Chris, but it's nothing like that. It's nothing like that. They're trying to get me help with this stuff and get stuff going.
What do you mean they're trying to get you help?
They're actually trying to help me because of this situation with housing and getting the kids settled and whatever. I'm got a pregnant daughter that's about to give birth in April that needs her mother. She has mental health issues. I don't care if it gets dropped against my oldest daughter, but the one that's about to give birth medically needs me there. I mean, I do care if it gets dropped. I apologize, but the emergency is Gabrielle.
Mr. Bayonetto, is Ms. Flores doing any kind of substance abuse testing as a part of her bond conditions?
Your Honor, I had asked for that in district court. I don't know that it was ever officially ordered. I believe Judge Shadler took it under advisement, but I don't know that she ever issued a formal order.
Your Honor, CPS, actually, I volunteered to take drug tests with CPS and they have those results if you would like them. I could take a drug test right now for you or anything you would like.
How about alcohol? Are you doing any alcohol testing?
I'm not doing alcohol testing. I don't drink alcohol like that, Your Honor, but I could easily do it. But I live in Jackson, on Stony Lake Road, which is between Jackson and Napoleon. So please ask, I work in Manchester. It's 40 minutes for me to drive here. There's no contact order. I can't be in my house right now. So I please ask the court considers all of this. I'm not on drugs. I'm not drinking alcohol. I'm willing to do anything to prove it. I work third shift. I maintained my job for 3 years. And it's a very hard physical job that most men can't do. But I show up every day and I do it. And I'm really not a bad person. I'm not on drugs. I'm not drinking. I don't have a problem. I have a problem with my husband. I'm going through a divorce now because of this. Was it drugs or alcohol? It was a man.
Sorry?
It wasn't, the problems was not drugs or alcohol. The problem had to do with a man, a toxic relationship.
Well, I watched the video in the other case where you had the incident with the police in the car, and everyone in the car other than the driver said they were drinking that night. So I'm not convinced that you're not using alcohol. There appears to me, what I know of your cases, to be some kind of an issue there that causes behaviors that have gotten you charged with crimes, and that's what I'm concerned about. You're asking me to drop a no contact order with someone that you've been charged with assaulting.
I haven't been charged with it, sir.
I'm sorry?
I haven't been charged. This was a lie. This all was a
You've
lie.
been charged with misdemeanor crimes of assaulting your 2 daughters.
I know, but there's no statement of assault
dispute
against Gabby in the statement. There's no statement of assault against her. That's why I don't.
I'm not here to argue your case today. I'm trying to explain to you why I'm hesitant in granting the request that you're asking. And why I'm asking some other questions about things that might be appropriate if I am willing to grant that request. Mr. Bayonetto has indicated that both of the victims in the assault charges have requested that those charges be dropped. Based on that, I am willing to remove the no contact provision. As I've indicated, I do have a concern based on what I know of the 24 case, that there is some kind of concern related to substances, including alcohol, for Ms. Flores. And so I am going to include as part of your bond conditions that you do alcohol testing with Mr. Coast from Pretrial Services.
I go about that living in Jackson.
You can talk to Mr. Coast and you can work something out.
I'm just asking
He's very
questions.
flexible and he will work with you.
Okay.
Are you still drug testing with Child Protective Services?
I can drug test whenever anybody asks me to.
Is Child Protective Services
Yes,
still requiring?
I volunteered the drug test and I've been volunteering drug tests.
I need you to slow down and listen to my question before you start answering. Do you have requirements through Child Protective Services?
No, I do not. I've been sober for 3 years. I'm sorry, this is very upsetting.
I understand that you're upset, but you keep cutting me off when I'm trying to ask you questions. And you being confrontational with me.
I said yes, so I've told you yes, there's drug testing with CPS. Yes, I've been drug testing it, yes. Yes.
I'm going to start talking, and I don't want you to say a word until I have finished talking. Do you understand that? Is the drug testing that you do through CPS required?
No, Your Honor. I passed the first drug test, no.
I'm also going to require that you do random drug testing with Darren Coast. If you're clean for until the next pretrial conference, I'll consider terminating that requirement at that time. Mr. Bayonet, is there anything else we need to address today?
No, Your Honor.
All right, Ms. Flores, I've made the bond condition changes that we have just discussed, and the next pretrial date is April 16th at 8:15 a.m.
Ms. Flores, I'm going to meet you out in the hallway so we could go over these breathalyzers with you.
No, actually, just Mr. Glazier, I have Mr. Clark here in person. Do you need to speak to him?
Yes, I do.
Sir Clark, can you step out to the hallway, please? There's an iPad right outside the door. Mr. Burkett, do you need to speak to Mr. Dill?
No, Your Honor, I do not.
And let's see, Mr. Malero, Ms. Betzer is here in the courtroom also. Are you going to need to speak to her?
Yes, Judge. Actually, Judge, if it's okay, I could just come over there and talk to her.
That'd be fine too.
All right, that's what I'll do. I'll be over there in a minute.
Okay.
Your Honor.
Yeah, if you want to step out to the hallway, Mr. Malero will be here in a few minutes.
Okay, thank you.
Thank you, Judge.
I don't care what they have. I'm welcome to participate in it, but the factors are Can we please put this over the fact that no sleep right now? I haven't slept over 24 hours. There.
Okay, Mr. Murphy, are you ready to proceed with Mr. Madison?
Yes, Your Honor.
This is file 3-21242-FH. 24-21997-FH and 24-21996-FH. People versus Brandon Lorenz Joe Madison. The 23 file is has a probation violation sentencing pending. The 24 files are set for pretrial. First, can I have the attorneys place their appearance on the record, beginning with Mr. Bannett.
Alex Bayanetto for the people.
Matthew Murphy appearing on behalf of Mr. Madison.
And Mr. Murphy, where do you stand with Mr. Madison's cases today?
Your Honor, in regards to the probation violation sentencing, we were willing to go forward with that today. I have discussed that with Mr. Madison. The new pending cases, though, we were going to ask for another pretrial. There's some things that are occurring that I think I need to talk to Mr. Madison about. And right now, the offer in place is not something that Mr. Madison will want to take. I think that another pretrial will be more appropriate right now instead of setting it for trial. However, if the court does want to set for trial, I think that we could do that. I guess it might only be a one-day trial. But I did want to, again, I think that maybe another pretrial will be more appropriate. But again, in regards to the sentencing, I didn't know if Your Honor wanted to continue with that today. From my understanding, I mean, the recommendation that I have, I've gone over with Mr. Madison. I don't know if it's been changed at all since that. But if, of course, the court wanted to adjourn it to the date of another pretrial, then we're fine with that too.
Mr. Bannett, is there anything to add from the people's side?
No, Your Honor. There, I guess actually yes, there, Your Honor. I did relay to Mr. Murphy there is potentially new charges coming for Mr. Madison. There's some research I have to do into that matter, so that I think a pretrial might be more appropriate given that, but I would defer to the court's discretion.
Are the potential new charges in any way related to the current charges?
No, Your Honor, it is a controlled substance offense.
What?
All right, so the 24 cases are 158 days old at this point. I don't think at this point I want to wait any longer to schedule the trial. I understand it's a fluid situation, and if there are some other charges that might impact what a plea looks like, but I just can't wait forever waiting for things to happen, because while we wait, additional things seem to happen. So I need to get it on the books and set it for trial. So Mr. Bannett, first of all, I guess, would these be tried together or separately?
I think they'd be tried separately, Your Honor. They're not, I don't know that they're necessarily related enough to combine them. But I think whichever case we try first, either one would take a day.
All right, so let's set the 996 case for trial. We can put that out a bit so that perhaps this issue can be resolved. So Ms. Clark, could you find us a one-day jury trial date, maybe the end of April or beginning of May?
Yes. Tuesday, May 6th at 9 a.m.
That would work for the defense.
That would work for me as well, Your Honor.
Okay, so let's do a final pretrial then on April 30th at 8:15. And we'll just do the lower case number unless someone prefers otherwise, the 996 case.
That's fine with the defense, Your Honor. Thank you.
That's fine with me as well, Your Honor.
right, so I'm going to adjourn all or both of the other files then to that final pretrial on April 30th.
Yes, Your Honor. Thank you.
All right, Mr. Madison, you're done with court for today. You can go ahead and log out.
Yes, sir.
Mr. Madison, like I said, contact my office today or tomorrow, okay?
Yeah, because they just said some crazy shit. Okay. Is it just me and you?
No, it's not just us.
Okay.
You're done with court for today, okay?
So come
Give my
see
office a
you.
call later today or tomorrow, okay?
Okay.
All right, Mr. Dill, I need you to unmute your device and send your request to start your video. All right, and Mr. Burkett, are you there?
Yes, Sean, I'm here.
Okay, so this is file 24-21967-FH, People of State of Michigan versus Deontay Laquan Dill. We are here today for a pretrial conference, I'm sorry, for an arraignment in this case. And we are proceeding today by video conference. Do we have someone from the prosecutor's office that can handle this?
Sorry, Judge. Just stepped
There
out
we
for a second. Phoebe McClure, F the people.
And Mr. Burkett, you want to place your appearance on the record?
I'm sorry, yeah. Good morning, Raymond Burkett on behalf of Mr. Deal. And Mr. Deal, will you identify yourself in this honorable court?
Yeah, Deontay Deal.
Okay, so this is a rearrangement after the case was remanded back to district court and then bound over once again. So Mr. Burkett, does Mr. Dill wish to have the information read?
We waive the information and stand mute to the charges.
All right, and court will enter a not guilty plea then for Mr. Dill. Where this case was originally bound over back in September, where do we stand with it? Are we ready to set a trial date?
No, Your Honor, I'd like to bring the court up to date on what really went on with this case, if I might.
Okay.
Your Honor, this honorable court heard motions that I had filed a couple of months ago, and this court ruled on the motions. And the court, after it ruled on the motions, we were asking the motion that the court dismiss the case. The court sent it back to the district court about 6 weeks ago, and with certain things that the district court was supposed to do. The district court, Your Honor, a couple of things. The district court agreed with the court order and decided that the circuit court, Your Honor, should have just dismissed the case based on the motion that we filed and refused to do anything other than that. In the meantime, Mr. Sneed, the prosecutor, offered a plea in this case and gave us to April 2nd to accept that plea. I discussed that plea with my client. The problem is my client has taken the position, and I can't disagree with him, that once the district court ruled that this case should have been dismissed, then why are we back into the circuit court? Because he doesn't want to plead to something that the district court has already ruled that the case should be dismissed. And I guess that's where we are today.
Okay, well, it appears that this was bound over back to circuit court based on a waiver. So you're back here because apparently Mr. Dill has waived his preliminary exam that I sent it back downstairs for.
Yeah, well, the judge ruled, after the judge ruled that there was nothing for her to decide. She had already decided it once before, and we had filed the motion up with you in the circuit court, and you had ruled on the motion. There was nothing for her to hold anything. So so the prosecutor and I suggested, well, then send it to you and let you decide what to do with it. Because you had already ruled on our motions.
Ms. McClure, anything from the people's perspective on this?
Just because I'm not privy to all the discussions between Mr. Burkett and Mr. Sneed or the court's rulings, I guess I would suggest maybe a bench conference and then followed by a pretrial or a motion hearing if that's what's needed. And I have Mr. Sneed's availability, so.
All right, what I'd like to do is adjourn this for a pretrial conference on April 16th. And in the meantime, have a bench conference with Mr. Burkett and Mr. Sneed so I can gain a better understanding. I don't know if I'm going to need the district court's transcript or exactly how we move forward from here. So that is how I would like to handle it. So Mr. Burkett, I'll ask you to get in touch with Mr. Sneed and schedule a bench conference with Ms. Clark in my office sometime between now and April 16th.
Will do, Your Honor.
And Ms. McClure, would the prosecutor's office be willing to do a stipulation in order for that adjournment, please?
Yes, we can.
Mr. Higgins, I apologize. There's some confusion. We've already handled your case for today. We don't need you any further.
Oh, okay. All right. Thank you.
Actually,
Okay.
Judge, I'm sorry, because Mr. Dill's a rearrangement, would it just be a notice?
Oh, you're right.
Okay.
You're right. I apologize.
Yeah.
So the court will just send a notice for the pretrial date. And again, Mr. Burkett, if you would coordinate a bench conference between now and the pretrial date, I would appreciate that.
Certainly, yeah, appreciate it. And the pretrial date will be by Zoom?
Correct.
Okay. I will contact Mr. Sneed.
Okay, thank you. We're all set then. Mr. Dill, you can go ahead and log out.
Thanks.
Mr. Murphy, do you need to speak to Mr. Parrish?
If I could, please, Your Honor.
Mr. Malero, are you ready to proceed with Ms. Betzer?
Yes, we are ready.
Okay, Mr. Parrish, I'm going to put you in a breakout session with Mr. Murphy.
Okay.
Okay, this file 24-22061-FH and 24-22062-FH, People versus Alexis Marie Betzer. We are here today for a pretrial hearing in both cases, and there's also a pending contempt in both cases. We are proceeding partially in person, partially by video conference. First, can I have the attorneys place their appearance on the record, beginning with Mr. Van Etten?
Alex Bayanetto for the people.
Salvatore Malero on behalf of Alexis Betzer.
All right, and Mr. Malero, where do we stand with Ms. Betzer's case today?
Your Honor, we have tendered a signed plea agreement to the court, terms of which are that Ms. Betzer will plead as charged on 24-22062 FH, that 22-22061 FH will be dismissed at time of sentencing, and no objection to drug court, which is also known as recovery court. And I was informed a little bit ago that Ms. Betzer was accepted and approved for recovery court. That would be our
Mr. Urbano, is that a complete and accurate statement of the plea agreement?
It is, Your Honor.
Ms. Betzer, would you raise your right hand, please?
yeah, sure.
I swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty for perjury.
Yes, Your Honor.
And you are Alexis Marie Betzer.
Yes.
You put your hand down if you want.
Thank you.
You've heard the statement of your attorney and the prosecuting attorney. Is it your intention to plead guilty today and file 24-22061-FH to count 1, possession of cocaine less than 25 grams?
Yes, Your Honor.
Do you understand that the maximum possible penalty for that offense is up to 4 years in prison and or a $25,000 fine?
Yes.
Are you satisfied with Mr. Malero and the advice that he's given?
Yes, Your Honor.
Neither the prosecutor, defense attorney, or anyone acting on the defendant's behalf has discussed a possible sentence with the court other than as we discussed on the record here this morning. Is that correct, Mr. Banetto?
That's correct, Your Honor.
Mr. Malero?
Yes, Your Honor.
Is that also your understanding, Ms. Betzer?
Yes, Your Honor.
If a guilty plea is accepted, there'll be no trial. That means you're giving up the rights that you would have had at trial. And explain those rights to you now to make sure that you understand them. You do have the right to a speedy public trial by jury. You could ask for a non-jury trial, and if the prosecutor and the court agreed, you could have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty, and you do not have to prove anything. You have the right to be present at trial and have the witnesses against you appear at your trial and to ask those witnesses questions. You have the right to have the court order any witnesses that you have for your defense to appear at your trial. You have the right to remain silent during your trial and not have that silence used against you. However, you also have the right to testify at your trial if you wanted to testify. You understand that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at a trial.
Yes, Your Honor.
Do you also understand that any appeal from the conviction and sentence pursuant to your plea would be by application for leave to appeal and not by right?
Yes, Your Honor.
If you are not a citizen of the United States of America, conviction of a crime can result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Do you have any questions about any of the rights that I've explained to you?
No, Your Honor.
And do you understand that you're giving those rights up?
Yes.
How do you wish to plead to the charge that on or about September 25th, 2024, in the city of Adrian, County of Lenawee, State of Michigan, that you did commit the offense of possession of cocaine of less than 25?
Guilty, Your Honor.
Has anyone made any threats or promises to you to induce you to plead guilty to that charge?
No.
Do you understand that if I accept your plea, you'll be giving up any and all claims that your plea was given as a result of threats or promises that were not disclosed to the court on the record today, or that it was not your own choice to enter the plea?
Yes, Your Honor.
Is the prosecutor or defense counsel aware of any promises, threats, or inducements other than the plea bargain to induce Ms. Betzer to plead guilty today?
No, Your Honor. Did I hear the court say possession of cocaine? I think it's possession of methamphetamine, Your Honor. It's the pleas in 24-22062.
Oh, yeah.
I apologize.
I was confused too. I'm sorry.
Sorry, Judge. I
looked at the wrong file.
It should be the November 3rd offense.
Okay.
Yeah.
I apologize, that was my mistake. So, Ms. Betzer, you understand that I read the wrong file, so it's file 24-22062-FH. And the charge in that case is possession of methamphetamine. Do you understand that?
Yes, yes, Your
Do you understand that the maximum possible penalty for that offense is up to 10 years in prison and or a $15,000 fine?
Yes, Your Honor.
You understand that that's a more serious sentence than the one that I read for the possession of cocaine charge?
Yes,
And you still want to enter your plea to this charge?
yes, Your Honor.
Okay, how do you plead to the charge that on or about November 3rd, 2024 in the city of Adrian County of Illinois, state of Michigan, you did commit the offense of possession of methamphetamine?
Guilty.
Your Honor, if I may, should we vacate the guilty plea on the other file? Just for purposes of housekeeping.
Yeah, I'll just not accept that plea
Thank you.
on the 24-22061 file. And again, we're proceeding only with respect to the 24-22062 file.
Thank you.
Ms. Betzer, you understand that all of those rights that I explained to you, you would have with respect to this file and this charge as well?
Yes,
And you understand that, just as I said to you, you're giving up those rights?
yes, Your Honor.
You still want to proceed with entry of this plea to the possession of methamphetamine?
Yes.
Okay. All right, and I'm sorry, Mr. Bano, you answered, I've forgotten, but are you aware of any promises, threats, or inducements other than this plea bargain to induce Ms. Betzer to plead guilty today?
No, Your Honor.
Mr. Malero?
No, Judge.
Ms. Betzer, has your attorney promised you any particular sentence or estimated what your sentence would be?
No, Your Honor.
Is it your own choice to plead guilty today?
Yes.
Mr. Malero, do you want to cover the factual basis?
Absolutely, Judge. Ms. Betzer, is it true that in the city of Adrian, County of Illinois, state of Michigan, that on or about November 3rd of 2024, you were in possession of methamphetamine?
Yes.
And you knew you were in possession of methamphetamine?
Yes.
And you knew you did not have any legal right to possess that methamphetamine?
Yes.
You also knew that it was contrary to Michigan law, specifically Michigan compiled law 333.74032B. Yeah. Is this court state satisfied?
Sir Baynett, are the people satisfied?
Yes, Your Honor.
All right. I will accept the plea. It's been given understandably, voluntarily, and accurately. Ms. Betzer has had full knowledge of her rights. She's had competent counsel. I will refer this matter to the probation department for pre-sentence investigation.
Do I go to the one up here?
I'll tell you.
Okay, sorry.
And we'll set sentencing for May 2nd at 8:15 a.m.
Thank you, Your Honor.
Your Honor, may we adjourn the contempt out to that date?
Yes, we can adjourn the contempt in the, that is just in the 061 file to that date of sentencing.
And Judge, she has done a little better as far as testing. She has been tested for her last few drug screens.
Okay. So Ms. Betzer, you'll need to step across the hall to the probation department. They'll have a packet of information to give you and some instructions about it.
Okay, thank you.
All right, so you're all set for today.
Thank you, Judge.
I have a device logged in at the Monroe County Jail. There we go. You're Mr. Lyles?
Yes, sir, I am.
Okay. This is file 22-20789-FH, People versus Jacoby Wayne Lyles. We are here today for a arraignment on a bench warrant for probation violation. We are proceeding today by video conference. Mr. Lyles, are you able to hear and understand me all right?
Yes, sir, I am.
Have you received a copy of the warrant?
No, sir, I have not.
All right, we will arrange to get you a copy of that warrant. I will tell you that the warrant alleges that you violated your probation by failing to report any police contact regarding your outstanding CCW warrant. That would be a technical violation. It also alleges that you violated your probation by violating criminal law or being arrested for CCW in Monroe County on November 9th, 2024.
Yes, sir.
You had, in this case, previously pled guilty to assaulting, resisting, obstructing a police officer, and the maximum possible penalty for that offense is up to 2 years in prison and or a $2,000 fine.
Right.
You do have the right to be represented by an attorney here today and at any other proceedings we have regarding this matter. If you can't afford an attorney, you can tell me that now. I'll appoint one for you from the public defender's office. Do you understand that?
Yes, sir. I was actually trying, if anything, I got a Goldstein as my attorney on the other one. And I was hoping, I've been here since January 21st. And I was hoping, and the concealed carry weapon was dropped. I had a concealed carry weapon, a controlled substance, which was Tylenol 3s, and they were my
Okay, I want you to slow down. I want you to slow down, Mr. Lyles. We're getting too far ahead of the situation. So right now, what I need to know is whether you want to be represented by an attorney or not.
Yes, sir. David Goldstein.
Okay, are you going to hire him?
Yes.
Okay.
I was actually hoping to run this concurrent with the time I'm
okay.
already.
I understand all of that, Mr. Lyles, but you said that you want to be represented by an attorney and that you're going to hire Mr. Goldstein. I don't have Mr. Goldstein here today.
Well, can I get a court appointed?
Well, do you have the ability?
Sir?
Do you have the ability to pay for your own attorney?
Not right now, I do not. Because I'm actually incarcerated and don't plan. I'm already doing 90 days here, sentenced.
All right, I'll have you speak to Ms. Underwood from the Public Defender's Office. And
I'll go back.
She will have some questions for you about whether you qualify for a public attorney or not.
All right, thank you.
Okay, she's getting logged in on her computer right now, Mr. Lyles. As soon as she's logged in, I'll put you in that breakout room.
Yes, ma'am.
Mr. Murphy, are you ready to proceed with Mr. Parrish?
Yes, Your Honor.
This is file 24-21846-FH People versus Deshaun Michael Parrish. We are set today for a final pretrial conference in this case, and we are proceeding today by video conference. First, can I have the attorneys place their appearance on the record, beginning with Mr. Bayonet?
Alex Bayonet for the people.
Matthew Murphy, appearing on behalf of Mr. Parrish.
All right, so this is a final pretrial. Are we ready to proceed to trial with the case?
Your Honor, the defense is ready to proceed with some amendments I'm going to have to make to the witness list to correct a name. And also, I believe that we'll probably file, because I'm going to file an amended witness list. And I believe that myself and Mr. Baynetto are going to enter some stipulations. And again, I'll probably file that with that amended witness list just to make that record clear, and submit that to Mr. Baynetto to make sure we're clear on that. But as it is right now, my understanding of the offer from the prosecution would be for Mr. Parrish to plead to, I believe, the the 5-year embezzlement charge, which is embezzlement 1,000 to 20,000. No contest with probation to run concurrent with whatever he might get with a pending or a sentence that's pending to come next week in Hillsdale. Am I correct on that offer, Mr. Bernardo?
That's correct. The agreement would also include no upfront jail. I will keep that offer open probably until Tuesday. At least give him an opportunity to be sentenced in Hillsdale. But yes, that is a correct recitation of the agreement.
So again, Your Honor, with that, the defense is ready to proceed to trial at this time.
Mr. Bano, anything from the people's side?
No, Your Honor, we are prepared to proceed to trial. We've been, Mr. Murphy and I have been in contact. As he said, we are also going to be filing our final witness list. And we will have the stipulated evidentiary concerns ready for the court, and I will make sure all marked exhibits are presented to the court.
All right, have jury instructions and voir dire questions been submitted?
Yes, Your Honor.
Yes, Your Honor. We had submitted those, I believe, previously in probably back before a December date. And there were no changes to that from the defense. I believe the prosecution had submitted prior to that, and were making no changes, I believe, as well.
That's correct, Your Honor. I think they were all submitted prior to the last final pretrial before the trial was vacated.
Thank you. Yeah, I forgot about that. Okay. All right, so we're set for trial then on March 20th at 9 a.m.
Thank you, Your Honor.
Anything else we need to address today?
No, Your Honor. Thank you.
No, Your Honor. Thank you.
Thank you.
All right, Deshaun, just contact my office later, okay?
All right, I will. I'll give you guys a call.
All right, thank you.
Yep.
All right, Mr. Murphy, have you heard from Mr. Henderson at all?
Your Honor, he had contacted my office yesterday, and I tried to reach out. Let me get that clarification.
Ms. Dumont, do you need to speak to Ms. Burciaga?
Your Honor, she sent me a message. She is stuck currently in a Hillsdale sentencing. She should be back on momentarily.
Okay. Ms. Burciaga will get to your case as soon as Ms. Dumont gets logged back in.
Okay.
Your Honor, would you give me just 5 minutes to try to reach out to Mr. Henderson again and see if I can contact him for this morning?
Yes, that's fine.
Thank you.
Judge, I just wanted to check and make sure I didn't miss anything. Did we already handle Larry Clark or Michael Turner?
No, I'm waiting for Mr. Glazer to get logged back in here, even over to Judge Anselm's court.
Okay, all right, thank you.
Your Honor,
Yep.
could I have a brief breakout with Mr. Jones?
She's on phone.
Yeah, one second. Mr. Jones, are you there?
And Judge.
Put you in a breakout room with Ms. Underwood.
Your Honor, can I go back in the breakout with Mr. Lyles briefly?
One second. All right, we are back in the record in People versus Jacoby Wayne Wiles. We actually had two files here. It was file 23-21433-FH and 22-20789-FH. Ms. Underwood, do you want to place your appearance on the record?
On Underwood, Your Honor. For Mr. Wiles.
All right. First, let me just have a moment, Ms. Underwood. I when I originally called the case, I did mention file 23-21433-FH. There's a warrant in that case as well, alleging the same violations that I've already advised Mr. Wiles of. In that case, he had previously been convicted of assaulting, resisting, obstructing a police officer. It has a maximum penalty of 2 years in prison. Also, in that case, operating while intoxicated. And the maximum possible penalty for that offense is up to 93 days in jail. Okay, so Ms. Underwood, go ahead then.
Your Honor, I believe Mr. Wiles probably qualifies for court-appointed counsel. However, that being said, if Mr. Wiles wants to retain Mr. Goldstein, he is more than welcome to do that.
Mr. Lyle, do you want to proceed with Ms. Underwood, or do you want me to set it over for a week so you can contact Mr. Goldstein?
I'm honestly confused because she just told me talk about taking a plea today. And if there's any possible way that I could take a plea to 90 days, I'll plead guilty today and run it concurrent with the time I'm already sitting, if that's a great possibility. I've been here since January 21st. My out date here is March 31st. If I'll do this time on top of this time, I'll come sit 30 to 60 days there, preferably 30. And my grandma was dying down there in Texas. My kid, I can't get a hold of him, can't talk to my son. It's really bothering me. My dad's not doing well in Texas, and honestly, I've lost job opportunities because of having to report every other Tuesday, and all types of other things. I'm just trying to get this behind me. I know I made mistakes in my life, and my background's not the prettiest. I just want to move forward and get out so I can focus on my kid. My son turns 4 June 13th, and I'm trying to be out for that free and clear. That way I can focus on him. I'm actually paying $640 a month in child support, so I can't afford probation plus that, and then trying to get me a place to live within the first month of me being released due to, I'm actually got nowhere to go upon my release. So that's another reason I'm not really trying to take probation or anything. I'd like to just run it a 93-day sentence if that's a great possibility.
I can't make any guarantees to you, Mr. Lyles, about what your sentence is going to be if you plead. If you plead, there will be an update of your pre-sentence investigation, and the probation officer will make a recommendation about what he thinks an appropriate sentence is, and then ultimately I would decide on what the appropriate sentence is. But I can't tell you what that is today because I don't have that information in front of me.
So I got a question. What's the max you would give me?
I can't answer that. I can tell you what the maximum possible penalty for your offenses are, and I've done that. For the resisting and obstructing a police officer, the maximum possible penalty is up to 2 years in prison. With respect to the operating while intoxicated, the maximum possible penalty is 93 days in jail.
Is there any possible way if I was to take a plea today and then sentence next week that we could run the time I've been here concurrent?
If you were sentenced next week, your sentence would start on the day of the sentencing. So to the extent that there's overlapping time, you would get credit for both.
So I get credit for this and then whatever time. Like this would go with the time y'all give me, right?
I don't understand what you mean by that.
The time I've been here, because I've been here since January 21st.
No, you would not get credit since January 21st. You would get credit since today.
Okay, well, run it because I'm already in jail. Let's plead guilty today and be sentenced next week.
You want to have any further discussion with Ms. Underwood before you do that?
Yeah, if there's a possibility of me talking to Mr. Jones, I'd like that.
Mr. Jones, you want to speak to Mr. Lyles?
Judge, I can, but I'm not sure it would be a productive conversation, just based on what he's been asking the court. I'm not going to agree to anything for him if that's what he's asking. I'm going to do my report as required and provide it to the court. I've spoke to his attorney about my thoughts. I told her that I'm going to ask for some jail time. I didn't give any specific jail time recommendations, anything of that nature. So if you would like me to, Judge, I can, but I don't know if it's going to be a productive conversation.
Mr. Lyles?
Yes, ma'am.
With the discussions that we have had.
Yes, ma'am.
And what you've heard from the bench, do you wish to take a plea to the violation today?
Yes, ma'am. Yes, ma'am.
All right.
All right. Would you raise your right hand? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty for perjury?
Yes, sir.
Do you understand that you have a right to contest these violation of probation charges and to have a trial on them?
Yes, sir.
You can put your hand down if you like. Do you understand that throughout that trial, you'd be presumed innocent until your guilt is proven by a preponderance of evidence?
Yes, sir.
You would have the right to have all of the witnesses against you appear at your trial. You or your lawyer could ask those witnesses questions. And you also have the right to have me order any witnesses you have for your defense to appear at your trial. Do you understand all of that?
Yes, sir.
You are not required to testify at your trial, and no one can say anything about you not testifying or hold that against you in any way. Do you understand that?
Yes, Your Honor.
On the other hand, do you understand that you have a right to testify if you wanted to testify?
Yes, Your Honor.
How do you plead then to the charge that you violated your probation by failing to make a truthful report, by not reporting your police contact of your outstanding CCW warrant to your probation officer?
Does plead guilty. Can I also say something? The CCW warrant was dropped to a use of non-narcotic.
Okay. How do you plead? How do you?
Sir?
Yes?
No, I was go ahead.
How do you plead to the charge that you violated your probation by violating a criminal law of the state of Michigan?
Guilty.
Do you understand that by pleading guilty, you're giving up a right to a trial and your right to have your lawyer's assistance at that trial, as I've already explained?
Yes, Your Honor.
Has anything been promised to you in order to get you to plead guilty?
No, Your Honor.
If I accept your plea, you're giving up any and all claims that your plea was given as a result of threats or promises that were not disclosed to the court on the record this morning, or that it was not your own choice to enter the plea. Do you understand that?
Yes, Your Honor.
Is it your own choice to enter the plea?
Yes, sir, Your Honor.
So you've been on probation in this case since back in September of 2022, is that right?
Yes, Your Honor.
And one of the requirements of your probation was that you were supposed to report any police contact to your probation officer in a timely fashion. Is that correct?
Yes, Your Honor. I actually couldn't because I was actually incarcerated January 21st. and I didn't bond out on this. I just took a plea deal to hope and pray to run everything concurrent. I've been here since January 21st, and the days, 50 days I've been here. My release date from here is March 31st due to me doing a opioid education
Okay,
class.
Mr. Lyles, I can't have you go through the entire thing every time. I don't have time for that today. So are you saying that you had no ability to contact Mr. Jones and let him know that you had been arrested?
Yes, sir. I had no ability. I couldn't call him. I mean, you can't call from county jail.
So what day were you arrested?
I was arrested and incarcerated January 21st.
And what were you charged with when you were arrested?
I was charged with use of non-narcotic. They dropped the concealed carry weapon and dismissed the.
Okay, I don't want to know what they dropped. I asked you what you were charged with. Were you charged with carrying a concealed weapon?
Yes, I was. Yeah. That I bought from Monroe, TA. Yes, sir, I was.
Ultimately, you entered a plea deal to something lesser. Is that right?
Yes, sir.
What did you plead to?
Use of non-narcotic.
All right, so I can accept the plea on the violation of a criminal law. I can't accept a plea on the failure to contact Mr. Jones. Mr. Jones, how do you want to proceed with that? Do you want to, we can continue with it and have a trial, or we can
Judge, I'm fine with that. I would just ask that, being that the warrant was dated November 9, 2024, he had police contact before that, but I'm fine with the court removing that as long as the other violation is acceptable.
All right. So I'll accept a guilty plea on the violation of criminal law charge, and we'll dismiss the failure to inform his probation officer charge. The plea has been given understandably, voluntarily, and accurately. Mr. Lyles has had full knowledge of his rights. He's had competent counsel. I will refer this matter to the probation department, to Mr. Jones, for an update on the pre-sentence investigation.
Judge, can I ask that we go through the other file as well?
I'm sorry?
We have that second file as well. I just don't want the court to forget that one.
Yeah, the charges were the same in both files.
Okay,
So everything applies to both files.
Thank you. Thank you.
Yeah. And so we'll set sentencing for March 21st at 8:15 a.m.
Thank you, Your Honor.
Mr. Lyles, Mr. Jones is going to get in contact with you to do an update of your pre-sentence investigation interview. When you do that interview, please be truthful about this offense and about your background.
Yes, sir.
All right, you're all set for today. You can go ahead and log out.
Thanks, sir.
Mr. Glazer, are you ready to proceed with Mr. Clark?
Yes, Your Honor.
Okay, this is file 24-22077-FH, People versus Larry Dean Clark. We are here today for a pretrial conference in this case, and we're proceeding today partially in person and partially by Zoom. First, can I have the attorneys place their appearance on the record, beginning with Ms. McClure?
Evie McClure on behalf of the people.
John Glazer on behalf of Mr. Clark.
And sir, you're Larry Dean Clark?
Yes, sir.
Okay, so we have this set for pretrial. Also, there's a pending contempt. Mr. Glazer, where do we stand with Mr. Clark's case today?
I spoke with Mr. Clark, and I guess he wants to set this for trial.
Okay, Ms. McClure, do you know how long will be needed for trial?
It looks like, so this is Mr. Sneed's case and it looks like it's a possession, so maybe just a day.
Mr. Glazer, you agree today is a sufficient amount of time?
Yes, Your Honor.
Okay, Ms. Clark, can we have a 1-day jury trial date, please?
Thursday, April 17th at 9 a.m. Backed up to a jury trial.
April 17th at 9 a.m. Is that available for Mr. Sneed and Mr. Glazer?
I assume it is, Your Honor. If not, we'll get back in touch with your office.
It looks like he's available.
All right, so April 17th. Let's do a final pretrial on April 9th at 8:15.
Mr. Clark, you should set an appointment to come in and see me like next week.
Absolutely.
Okay, anything else we need to address with this case today?
No, Your Honor.
Judge,
No.
reference the contempt. His last 3 drug screens have been clean. So I suggest that we put this out until that final pretrial, April 9th.
Okay, thank you. We'll adjourn the contempt to the date of the final pretrial as well. All right, you're all set, Mr. Clark. Thank you.
Thanks, sir.
Thank you, Your Honor.
All right, we will call for Turner right now. Ms. Dumont, do you need to speak to Ms. Burciaga?
No, Your Honor, we're ready.
Okay. This is file 25-22115-FH, People of State of Michigan versus Karina Burciaga. We are here today for a pretrial conference in this case. And we are proceeding today by video conference. First, can I have the attorneys place their appearance on the record, beginning with Ms. McClure? Oh, I'm sorry, was it Ms. Arnold?
Yes, Allison Arnold for the people.
Katerina Dumont for Ms. Burciaga.
Okay, Ms. Dumont, where do we stand with Ms. Burciaga's case today?
Your Honor, I recently filed a substitution of counsel. So what I'd be asking for is another pretrial to go over discovery and get a formal offer from the prosecutor. I have been in contact with Ms. Burciaga and Mr. Coast with regards to her drug testing. I believe currently she's doing twice a week, and she is having some trouble affording that. I know she's been clean on all of her drug screens. So what we would be asking is if we could modify bond in which she wouldn't have to pay, I believe it's $40 a week.
Ms. Arnold, any response to that?
As long as Mr. Coast verifies she's been testing clean the entire time, I have no objection to a bond modification for that reason.
And Judge, I just looked at her bond condition sheet. Her last 29 drug screens have been clean, and she's consistent and going. She's had 0 misses, so I'm totally fine with that 1 time a week.
Okay.
Is there any way that I could possibly get taken off completely?
Actually, Judge, we wouldn't object to that. Given 29 cleans in a row, I think that's appropriate.
We wouldn't object to that either.
All right. Okay, it does appear she's been testing clean since August of last year. Based on that, then I will eliminate the drug testing requirement for Ms. Burciaga.
Thank you.
Thank you.
And let's set a pretrial conference for April 16th at 8:15 a.m.
Thank you.
Ms. Dumont, will you do a stipulation in order for that adjournment?
Yes, Your Honor.
Thank you. anything else we need to address with Ms. Bursiaga's case today?
No, thank you, Your Honor.
Ms. Bursiaga, you're all set. You can go ahead and log out then.
Thank you. Have a good day.
Okay, Mr. Glazer, you ready to proceed with Mr. Turner?
Yes, Your Honor. I need to speak with him though.
All right, 1 second. And Ms. Demont, are you ready to proceed with Mr. Sebring?
Yes, Your Honor.
Mr. Sebring, I'm going to send your request to turn your video on. Mr. Sebring, if you're there, I need you to turn your video on and unmute your device, please. Are you there, Mr. Sebring?
Yes, he's here.
Okay, I need the video to be turned on.
All right, there you go.
No, your video is not turned on yet.
On the bottom. Let me have it again.
There you go.
Oh. Okay.
Okay, now I'm looking at the ceiling.
All right, how's that?
Okay. This is file 25-22111-FH, People of the State of Michigan versus Todd Bryant Sebring. We are here today for a pretrial conference in this case, and we are proceeding today by video conference. First, going to have the attorneys place their appearances on the record, beginning with Ms. McClure.
Phoebe McClure, behalf of the people.
Katerina Dumont for Mr. Sebring.
And sir, you're Todd Bryant Sebring, is that correct?
Yes, sir.
Ms. Dumont, where do we stand with Mr. Sebring's case today?
Your Honor, I just recently filed a substitution of counsel on the case. However, when looking at the file, it looks like there was an agreement with Mr. Sneed that after his co-defendant's sentencing, this case would be dismissed. And when I looked in the public ROA, it looks like his co-defendant is set for sentencing on March 14th. So we would just ask for a date after that and then give the prosecutor time to file that nolle.
Okay. What I will do is set that then for April 9th at 8:15, and then obviously if the nolle process entered before that date, there's no need to appear.
Thank you.
Ms. Dumont, would you do a stipulation in order for that adjournment? Yes,
Your Honor.
Okay, I think we're all set with that one then.
Thank you.
Jill, if they have a second, we would take Mr. Okay, Mr. Sebring, you can go ahead and log out, sir.
All right, thank you.
And Mr. Glazer, are you ready to proceed with Mr. Turner?
Yes, Your Honor.
This is file 25-22164-FH People versus Michael Joshua Turner. We are here today for an arraignment in this case, and we're proceeding today by video conference. First, can I have the attorneys place their appearance on the record, beginning with Ms. McClure.
Phoebe McClure, behalf of the people.
John Glazer on behalf of Mr. Turner.
And sir, you are Michael Joshua Turner?
Yes, Your Honor.
Mr. Glazer, does Mr. Turner wish to have the information read today?
No, Your Honor, we'd waive the reading of the information. I don't have a copy of it in front of me. Is it a 3-count information?
Correct.
Yeah, he's going to plead guilty, Your Honor, to the count of felonious assault. I'm not sure which count that is. I assume it's count 1. And then with the understanding counts 2 and 3 would be dismissed and the habitual offender would be dismissed. And we'd like to address bond if we can.
Okay, Ms. McClure, is that a complete and accurate statement of the plea agreement?
It is, Your Honor.
All right, Mr. Turner, would you raise your right hand, please? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty for perjury?
Yes, Your Honor.
You are Michael Joshua Turner, correct?
Yes, Your Honor.
You've heard the statement of your attorney and the prosecuting attorney. Is it your intention to plead guilty today to count 1, assault with a dangerous weapon, also known as felonious assault?
Yes, Your Honor.
Do you understand that the maximum possible penalty for that offense is up to 4 years in prison and or a $2,000 fine?
Yes, Your Honor.
Are you satisfied with Mr. Glazer and the advice that he's given you?
Yes, Your Honor.
Neither the prosecutor, defendant, or anyone acting on the defendant's behalf has discussed a possible sentence with the court. Is that accurate, Ms. McClure?
That's accurate.
That's accurate, Travis.
Okay. Is that also your understanding, Mr. Turner?
Yes, Your Honor.
If a guilty plea is accepted, there'll be no trial. That means you're giving up the rights that you would have had at trial. I'm going to explain those rights to you now to make sure that you understand them. You do have the right to a speedy public trial by jury. You could ask for a non-jury trial, and if the prosecutor and the court agreed, you could have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty, and you do not have to prove anything. You have the right to be present at trial, to have the witnesses against you appear at trial, and to ask those witnesses questions. You have the right to have the court order any witnesses you have for your defense to appear at your trial. You have the right to remain silent during your trial and not have that silence used against you. However, you also have the right to testify at your trial if you wanted to testify. Do you understand, Mr. Turner, that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at a trial?
Yes, Your Honor.
Do you also understand that any appeal from the conviction and sentence pursuant to your plea will be by application for leave and not by right?
Yes, Your Honor.
If you are not a citizen of the United States of America, conviction of a crime can result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Do you have any questions about any of those rights?
No, Your Honor.
Do you understand that you're giving them up?
Yes, Your Honor.
How do you wish to plead to the charge that on or about January 26, 2025, in Madison Township, Lenawee County, Michigan, that you did commit the offense of assault with a dangerous weapon?
Guilty.
Has anyone made any threats or promises to you to induce you to plead guilty to that charge?
No, Your Honor.
Do you understand that if I accept your plea, you're giving up any and all claims that your plea was given as a result of threats or promises that were not disclosed to the court on the record today, or that it was not your own choice to enter the plea?
Yes, Your Honor.
Is the prosecutor or defense counsel aware of any promises, threats, or inducements other than the plea bargain to induce Mr. Turner to plead guilty?
No,
No,
Your
Your
Honor.
Honor.
Mr. Turner, has your attorney promised you any particular sentence or estimated what your sentence would be?
No, Your Honor.
Is it your own choice to plead guilty today?
Yes, Your Honor.
Mr. Glazer, do you want to establish a factual basis?
Yes, Your Honor. Hey, Mr. Turner, back on January 26th of this year, you were here in Lenawee County in the state of Michigan. Is that correct?
Yes, Your Honor. Or yes.
Not Your Honor, just say
Yeah,
yes.
you're good. Yep. Yes.
All right. And then at that time, you were with a girl that you were dating, Lois Lowry. Is that correct?
Yes.
And you were at which hotel were you at?
Super 8.
You were at the Super 8. And during that time, you and her got into an argument. Is that correct?
Yes.
And during that argument, you hit her with the butt end of your knife.
No, that was not correct.
What did you hit her with?
The sharp end.
Oh, the sharp end.
Slice.
It came down in a downward
It
motion.
came pretty much a straight. I fell forward into the bed.
Okay.
That's what happened.
All right. So then the sharp end of the knife cut her in the back of the head.
Yes, Your Honor.
Is that correct?
Yes.
I don't have any other questions.
Ms. McClure, are the people satisfied?
People are satisfied.
Has the court complied with MCR 6.302 B, C, and D, Ms. McClure?
It has.
Yes, it has, Your Honor.
All right, I will accept the plea then. It's been given understandably, voluntarily, and accurately. Mr. Turner has had full knowledge of his rights and he's had competent counsel. The court has not made any agreement regarding the possibility of a plea or sentence in this case with the prosecutor, defense attorney, defendant, or anyone acting in the interest of any of them. I will refer this matter to the probation department for a pre-sentence investigation. And set sentencing for May 15th at 8:15 a.m.
You say May 15th?
Sorry, give me 1 second. Actually, we can do April 25th at 8:15.
All right. And I wanted to address bond if I could, Your Honor.
Okay, go ahead.
Your Honor, we'd ask the court to consider a PR bond. I don't even know what the bond is set at in this case. Obviously, my client has pled to a reduced charge of a 4-year felony. I would indicate criminal history wise, I think he has a retail fraud misdemeanor in 2018. And then he has the felonies that would be listed on the information, which I think are a stalking and looks like an R&O. And he also has a misdemeanor MDOP back in 2022. Other than that, he doesn't have any criminal history.
Okay, Ms. McClure, care for response?
Sorry, I had myself muted because I have a cough today. But I guess my position would be, I think Mr. Bandano and the victim in this case may be asking for continued jail time at sentencing. Excuse me. So I would just ask that he at least remain in until sentencing. That would be our position.
Okay, so looking at the habitual offender notice, Mr. Turner has 2 convictions for 4th degree fleeing a police officer, 1 conviction for aggravated stalking, and in this case has just pled guilty to assault with a dangerous weapon. That weapon was a knife, and it involved a fight with girlfriend. So although the domestic violence is being dismissed, it was a domestic violence situation. I think under the circumstances that his current bond of $20,000 is appropriate. I don't think in this case that a PR bond is appropriate, given that there seems to be some evidence that he could be a flight risk and other evidence that or that in this case he was convicted of an assaultive crime, and that coupled with a prior conviction for aggravated stalking makes me believe that some form of a cash bond is appropriate to ensure both his return for sentencing and the safety of the public. So I'm going to leave bond where it's currently set. Mr. Turner, someone from the probation department is going to be in touch with you to do the pre-sentence investigation interview. When you do that interview, please be truthful about the offense and about your background.
Yes, Your Honor.
You are all set with court for today.
And what, Your Honor, what was that date again?
April 25th.
April 25th.
Yes.
Thank you, Your Honor.
Thank you.
That's all I have for you this morning. Thank you, Your Honor.
Okay, thank you, Mr. Glazer. All right, Mr. Murphy, we can call the Henderson cases real quick. This is file 24-22020-FH and 24-22021-FH, People versus Jonathan Craig Henderson. These cases are set for pretrial conferences today. They also both have 2 contempt violations pending. First, I have the attorneys place their appearance on the record, beginning with Ms. McClure.
B.B. McClure, may I have the people?
Matthew Murphy, appearing on behalf of Mr. Henderson.
All right, the record should reflect this matter was set for hearing at 8:15 a.m. this morning. It is now 10:43 a.m. Mr. Henderson has not appeared here this morning, either by coming to the courthouse in person or by logging into the Zoom session. I would also indicate that I've received a note from Mr. Coast that indicates that Mr. Henderson, after being allowed to go to an inpatient treatment facility, left the treatment facility prior to his completion of the program, and at this point, I guess, at least I don't know where he is. Mr. Murphy, is there anything you want to say with respect to Mr. Henderson at this point?
Your Honor, Mr. Henderson had called my office and left a message a couple days ago, I think at lunchtime. The note says, I tried to call that number. It didn't go through and there was no ability to leave a message. I did that yesterday and again this morning. Mr. Henderson did email my office stating he was trying to appear in person in court, but I think that was well over an hour ago. So that's all the information I have for Your Honor.
And Judge, I did speak with him by phone on March 10th, and he was instructed to return to jail because he did not complete his treatment. And if he didn't do that, he had at least appear in person for this morning's hearing. So obviously he didn't do that.
Okay, Mr. Henderson has 3 prior contempts related to failing to do his drug testing, and Now, this obviously failure to appear at court, so I'm going to issue a bench warrant for his arrest. I'm going to set bond on the bench warrant in the amount of $25,000 cash or surety in each file.
Yes, Your Honor. Thank you.
Thank you.
Thank you. Ms. Underwood, are you ready to proceed with Mr. Molina?
Yes, thank you, Your Honor.
Okay, this is file 14-16856-FH, People versus Robert Paul Molina. We are here today for a hearing on an alleged probation violation. Mr. Molina was arraigned on that on Monday, I believe it was, and we set it for today. Ms. Underwood, do you want to place your appearance on the record?
Bond Underwood for Mr. Molina this morning, Your Honor. Thank you. Your Honor, Mr. Molina, this violation concerns a failure to pay child support, Your Honor, on an old child support case. And there is that matter. And then, Your Honor, the Office of the Attorney General also filed another charge based on the failure to pay this child support. We addressed that matter in district court this week, Your Honor. Mr. Molina's bond is the statutory 20%, 25% of what he owes. And the bond is currently on that case, some $15,000 and change, payable directly to the friend of the court in cash. We also waived exam in that matter, Your Honor, to have that case brought up here. And what I'm asking today, Your Honor, is we waived arraignment and wanted a quick pretrial. So I don't think we have a pretrial date yet, but I would like both of these matters scheduled for pretrial as soon as possible.
Okay, what, you did your waiver on Monday?
Yes.
So would that be next Wednesday? All right, so I'll set it for a week from today, March 19th at 8:15 a.m. I think it will be up here for arraignment on that date.
Thank you so much, Your Honor.
All right, anything else to address in this one today?
I believe that's it, Your Honor.
All right, Mr. Molina, you can let the officer with you know that you're done with court for today.
Okay.
Your Honor, what about Young and Raymond?
Neither of them have appeared, so we can do them right now.
Okay.
I'll do one, sir.
All right. Are they going to be bench warrants or?
Got more and Raymond. So we can do the
Thank
more
you.
first.
Oh.
Okay. This is file 20-19796-FH and 20-19849-FH. People versus Anthony Harris Moore. We are here today for a hearing on a summons to for a probation violation. We are proceeding today by video conference and in person. Record should reflect that this matter was set for a show cause hearing this morning at 8:15 a.m. It is now 10:50 a.m. Mr. Moore was ordered to appear and he has failed to do so. He is not present here in the courtroom and he has not logged into the Zoom session. So he has failed to appear. I am going to issue a bench warrant for his arrest, and I'm going to set bond on the bench warrant in the amount of $1,647. No, I'm sorry, I guess I should break that up. So it's $1,458 in the 796 file and $189 in the 849 file. Those are cash bonds, yeah. Okay, to Raymond. This is file 24-21808-FH and 24-21890-FH. People versus William Michael Raymond. We are here today for hearing on a probation violation in each of those files. Or actually, here on a request and summons for probation violation in each of those files. The record should reflect that this matter was set for a hearing on the summons today at 8:15 a.m. It is now 10:53 a.m. Mr. Raymond has not appeared either by being at the courthouse here in person or by logging into the Zoom session. So I'm going to find that he's failed to appear. I am going to issue a bench warrant for his arrest. I will set bond on the bench warrant to be $10,000 cash or surety in each file. Okay, I believe that is everything. Thank you, Rhonda.
Thank you. Have a good day.
Thank you, you too.